The Epstein Files Transparency Act concerns the disclosure of government records connected to the Jeffrey Epstein investigations and related matters. Jeffrey Epstein himself is deceased. More than half of the relevant documents have already been released through prior judicial and administrative processes. This act addresses remaining materials and specifies disclosure obligations tied to identified individuals. From a constitutional perspective, that framing matters. The question is not whether Congress may require disclosure generally. Congress does that all the time. The question is whether the structure of this statute, particularly the use of name-specific provisions, creates constitutional consequences. The Act does not operate through a criminal prosecution. There is no indictment, no jury, no trial. Instead, Congress legislates disclosure obligations directly. That legislative choice is what gives rise to the constitutional analysis. The Constitution explicitly prohibits Congress from passing any bill of attainder. A bill of attainder is a law that does three things. First, it specifies an individual or a readily identifiable group. Two, it imposes punishment. And three, it does so without a judicial trial. Courts do not treat this as a formalistic inquiry. They look at substance. The Supreme Court has identified three lenses for analysis. One is historical punishment, whether the law resembles punishments traditionally imposed by legislatures. Another is functional punishment, whether the law imposes burdens that operate like punishment in practice. And third is legislative intent, whether the statute appears designed to punish rather than regulate. Naming individuals in legislation is not automatically unconstitutional. Congress has occasionally done so in narrow circumstances. But the constitutional concern arises when naming individuals is combined with new legal disabilities or burdens. A modern analogy helps clarify this. Imagine Congress passed a statute that said a named individual may no longer contract with the federal government. There is no criminal charge, no judicial finding, no neutral process. Even if Congress labeled that law regulatory, courts would immediately ask whether Congress had crossed into punishment. The concern is not the label. It is who is deciding consequences and how. When Congress identifies specific people and legislates consequences directly, it begins to look less like lawmaking and more like adjudication. That is exactly what the Bill of Attainder Clause was designed to prevent. The Congress also forbids ex post facto laws. These are laws that impose punishment for conduct that occurred before the law was enacted. This principle is rooted in rejection of retroactive punishment by legislatures. Historically, ex post facto abuses occurred when lawmakers criminalized past conduct once someone became politically inconvenient. The prohibition applies most clearly in criminal law, but the analysis does not stop there. Courts look beyond labels. They ask whether a law is civil in name but punitive in effect. That inquiry focuses on several factors. Does the law look backward? Does it impose burdens traditionally associated with punishment? Does it advance retribution rather than regulation? A contemporary analogy makes this concern concrete. Suppose Congress enacted a law requiring named individuals to comply with new disclosure obligations based solely on decades-old conduct. There is no prison sentence. There are compliance costs. There is increased legal exposure. There may be loss of statutory protections that previously existed. Taken together, those burdens can function as punishment for constitutional purposes. The absence of incarceration does not end the inquiry. One set of constitutional arguments focuses on the cumulative structure of the Act. The statute identifies specific individuals rather than neutral categories. It attaches new legal consequences to conduct that predates the statute. And it operates without judicial adjudication. Viewed together, those features implicate both the Bill of Attainder clause and the ex post facto clause. The Constitution reflects a judgment that legislatures should not determine guilt, impose penalties, or retroactively after legal consequences, even in pursuit of legitimate policy goals. From this perspective, the concern is not the subject matter of the law. It is the precedent such a structure could establish. If Congress may name individuals and impose new legal burdens without a trial in one context, the logic does not remain confined to that context. The Constitution's safeguards are designed to operate before that point is reached. There is, however, a competing constitutional argument. That argument emphasizes the regulatory character of disclosure laws. Transparency requirements have long existed in federal law. They are routinely upheld when they serve legitimate governmental purposes. Under this view, disclosure, even when uncomfortable or damaging, is not itself punishment. Reputational harm alone has rarely been treated as constitutional punishment. Historical examples show that Congress may impose record preservation and disclosure obligations even in sensitive contexts, so long as the law does not resemble traditional punishment and does not reflect retaliatory intent. From this perspective, the Act may be understood as completing an ongoing disclosure process rather than imposing new sanctions. If that framing holds, the statute may fall on the constitutional side of the line. Even if constitutional questions exist, courts do not address them in the abstract. A case must first be properly before the court. That raises the issue of standing. Standing requires a concrete injury. That injury must be fairly traceable to the statute, and it must be capable of judicial redress. In this context, standing would most likely arise from legally compelled action. Examples include required disclosures, compliance costs, or loss of statutory protections. Pure reputational harm, standing alone, is usually insufficient. But when the law requires specific actions or alters legal rights, standing is typically satisfied. If a court reached the merits, the available remedies would be limited. Courts do not rewrite statutes. They choose from established forms of relief. A court could issue declaratory relief, stating that the statute or particular provisions are unconstitutional. It could issue injunctive relief, blocking enforcement of certain sections. Or it could sever name-specific provisions while leaving broader disclosure requirements intact. Historically, courts favor narrow remedies, especially where Congress could accomplish its objectives through neutral criteria. This discussion isn't really about EPSTEIN. It's about whether constitutional limits still apply when emotions run high and facts are ugly. The framers didn't write protections for popular people. They wrote them for moments exactly like this, when it would be easiest to abandon them. The question isn't whether transparency is good. It's whether Congress can achieve it without crossing lines the Constitution clearly drew.